Hello, welcome everyone. It's another Friday webinar. I'm Rilus Law. Thanks for tuning in. So today I got a couple exciting topics. So during this show, what I like to do is talk about what's come up during the week. So today's topic, we're going to talk about there's been a lot of litigation I've been dealing with, beneficiary rights. So we're going to talk about that, what to do if you're a beneficiary. And then the other topic is, can you litigate nicely? So that's today's topics. So let me share my screen here. All right, so I want to review just a little bit. I remember last week. So last week I was joined by Billy from Modern Family. I'm from Modern Law. She's a family law attorney, and really she's a legal business. We had a great conversation, talked about some of the new rules that Arizona is rolling out next year, allowing non-attorneys to practice law, non-attorneys to own law firms, attorneys to share legal fees, and it introduces an LP, legal practitioner. So go back and watch that show if you didn't catch that. It's on the YouTube and Facebook. I learned a lot just in that conversation with Billy. Made me think about my business a little bit differently and different options that we'll have next year. So today's topics, what to do if you're a beneficiary. And before we get into that, I want to show you some of my influences. So here we go. I got a little music in the background. I'm always rocking out to something in here. Akira the Don, DJ, inventor of Meaning Wave, where he puts words with music. People like Joe Rogan. The latest was with Marilyn Monroe. There's actually a one newer than that. But Elon Musk, a lot of interesting stuff. So it's a great way to take in information. And then One Rental at a Time. This is where I've been getting my financial news. So Michael Zuber, I recommend check out his channel. He goes live every morning about 7:30 and gives a report of the financial headlines. So I don't know about you guys, but I'm having a hard time watching the news lately or anything like that. But I like to stay informed. So this is where I've been getting financial news this year. I've really been enjoying it. So go check him out. Hit the subscribe if you like him. He's trying to build his following. Okay, so back to my presentation. What are your rights if you're a beneficiary? So if anyone's watching on the live, feel free to leave comments. Any other attorneys out there, I'd love to have you your comments and feedback as I go through this. Or if you've had any of these dealings yourself, beneficiary of a trust, feel free to chime in and ask your questions. So first I want to get into what is a beneficiary. So let's look at the statutes. So this is the Arizona revised statutes. Arizona Trust Code is known as all of this stuff. So the way that a beneficiary is defined, it's a person who either has a present or future beneficial interest in a trust, vested or contingent. Okay, interesting there. So future beneficial interest is still a beneficiary. And then another term I want to look at here is qualified beneficiary. So qualified beneficiary means a beneficiary who, on the date of the beneficiary's qualification, is determined as a distributee or permissible distributee of trust, income, or principal. Would be a distributee if the trust terminated on that date. So the future beneficiaries are also included as the qualified beneficiary. So if the trust were to terminate, who it would be paid out to, those are qualified beneficiaries. So we get a lot of calls in our office. I'll go back to this. We get a lot of calls. People say, what are my rights? There's a trust, or I think there might be a trust, and I want to know, what are my rights? So what should they do? So, well, what we need to figure out first is, who is the trustee? Do we know that? Do we know if there is a trust or what is controlling? So if there's no legal documents at all, it's what's called intestate, meaning no will. And then there's a default order for beneficiaries. So the intestacy determines beneficiaries and who has the priority to serve as a personal representative. So we got to figure out who's in charge. And then the first thing to do for beneficiaries is to request a copy of the trust and report. So let's go back into these statutes. The other thing I have pulled up here, another part of the trust code, 14-10813, duty to inform and report. So this is the Arizona trust code. It's very similar in California, the duties that are required of a trustee or fiduciary. But I like to point specifically to this law. So whenever we represent a trustee that's administering a trust, one of the first things that we do is this, inform and report. We give all the beneficiaries notice. So we give them a copy of the trust necessary to determine their interest, and then within 60 days after accepting trusteeship. Okay, so what does it mean to accept trusteeship? So after someone passes away, the successor trustee, even though they're named in the document, they have to do something to accept that. We have our clients sign a document called an acceptance of trustee to have them formally accept that duty. So it's not necessarily 60 days after the people pass away. It's after accepting the trusteeship. They shall notify the qualified beneficiaries of the acceptance and give them their name, address, and telephone number. So when we're representing the trustees, we give all the beneficiaries our contact information, because if they're reaching out to the trustee, we want them to call us, and since we're advising the trustee. So that's a big part of the service we provide. A lot of people don't want to deal with the beneficiaries and have that contact. And if you're named the trustee, the law requires you to do that. And then within 60 days after the death of the trustee, acquires knowledge of the creation of an irrevocable trust, or the date the trustee acquires knowledge that a formerly revocable trust has become irrevocable. Okay, so if a trust goes from revocable to irrevocable, then the trustee has to give notice. So an example of that, the common one is when someone passes away, the revocable trust turns irrevocable at that point. Or if the person that created the trust, the trustor, the settlor, the trust creator, if they resign as the trustee, then at that point the trust becomes irrevocable because there's no one that can change it. And we need to it needs to get a new tax ID number at that point to show that the trustee is managing it for the benefit of the trustor. While the trustor is serving as a trustee, it uses their tax ID number, their social security number as a tax ID number. All right, back to the PowerPoint. So if you're a beneficiary, what we like to do is, request that report. We point to that statute saying, here's what you should be doing as a trustee. Why haven't you done it? And then, we see what the response is, if we get a response. So here's another question we get a lot. How do you know if you're a beneficiary? So we get this call all the time. Maybe their parents pass away. They think they're a beneficiary of the trust or will, but maybe it's brother that's trustee and won't give them a copy or won't tell them anything. So then what do you do? So what do you do at that point? So we do some probates in California. California probates are a pain. They take a lot of time. It really depends on what assets are involved and what county. But you can shoot me an email and I can give you more information. And if I don't specifically handle probates in the county that you need, I can connect you with an attorney. but it's so specialized, like in California, county to county. So I really don't like to do probates, and unless it's a county like San Diego. Really, that's it. So that's really the only practice. That's the only county I'm practicing in California. All right, thanks for your question, Sergio. So what do you do if they don't respond? So how do you know if you're a beneficiary? So we just looked at at the law saying that the trustee is supposed to report, but how do you know that they're actually doing their duty? How do you prove that you're not in the will, or that they're well? So if you ask the trustee for a copy and they say you're not a beneficiary, you're not entitled to it. So if you're truly not a beneficiary, you're not entitled to receive anything. So, oops. Okay, so the first thing to do, you can ask, but if they don't respond, it's kind of tricky, because if you're not listed in there, they don't have to respond to you. They don't have to tell you that you're not a beneficiary. There's only a fiduciary duty and a legal duty owed to the named beneficiaries in the document or of the intestate estate. So what I recommend, what you should do, what should you do in that situation is, ask, and then if they don't respond, ask directly in writing. Make sure that you have a writing proof of what exactly you asked, and you'll see if they respond. And then the next step, you can hire legal counsel. And legal counsel is probably going to start off the same way. They'll ask directly in writing. And then if that doesn't work, the next step, how do you force answers? You have to file a lawsuit, some sort of lawsuit to force someone to have to give an answer. So when people ask us, what do I do if they won't show me a copy of the will, they say I'm not in there, how can I force them to? Well, litigation is the route you have to go to. Okay, I'll show you our fee agreement. This is we call it Benny rights. I always abbreviate beneficiary to Benny. I don't want to spell it every time. And this is an area of the law where our primary practice is estate planning. So I've throughout my career, what I've done, I've helped people establish plans, and I've helped them administer plans. That's the main thing that I do. But after gathering this, the knowledge in this industry, it's I see there's a lot of need where people are beneficiaries. So I've gotten into litigation cases, just to help people out, basically, because I don't want to see them get taken advantage of by others and other things. So we came up with a way. People in my office always hear me talk about how much I hate litigation. And people kind of think that's funny, how I'm a lawyer, but I hate litigation. And I hate all the inefficiencies of it. That's part of what I don't like about it. My other big complaint, and just being honest here, is I hate how it controls my schedule. That you got to go by the court hearings and all of that. And if they only have a date available a certain time, it's got to be that. So the way we get started with beneficiaries, when they say, what are my rights? We don't know. We can't help them, or we can't give good advice unless we look at the specific situation. So we've come up with a flat fee. It's usually $750. Sometimes it's as much as $1,000 or $1,500, depending on the situation. And what we'll do for that flat fee is we start reviewing documents if they're available. So whatever you have, we'll take a look at it and get familiar with it. And then if there's no will, then we'll look up the laws and determine who the beneficiaries are. We'll review whatever asset information that you have. So if you have any financial statements or deeds to real estate, or we'll search on the public records and see what we can find. There's not a good way to search for assets after someone passes away, and that's kind of it's a common misconception. People think that we have a way where we can search everything in a person's name after they pass away. We don't have a good way. So, it's just, deeds and properties, things like that are recorded. So we'll, try to figure out what the assets are. And then we'll make contact with the trustee or personal representatives, and we remind them of their duties. So the first contact, always try to be nice, remind them of their duties, and see what's going on, and then we report to the beneficiaries. Now, if the documents are not available, we'll request them as well, and remind them, specifically, here's the law in these two places. So for the trustee, that's where I was just looking at, and a personal representative in a probate or an estate is right here, 143705. And then after that, so we'll take a look at all the information there is. We'll make contact, see what the response is, and we've gotten some really good results with just this level 1 engagement for people. We've gotten trustees to make payments and do other things that they said they weren't going to, and so it's been great for a lot of people. I feel like they've had a really good result. Oftentimes though, this doesn't get it done. This first level doesn't get it done if we have a trustee who's still not following their duty, or maybe there's questions to be asked as far as maybe some assets are missing, or there's unclear accounting or things like that. Then we have to move into a level 2 engagement. So level 2 engagement is it's going to vary depending what we find out in the first level, but it's somewhere between $1,000 to $5,000 retainer, and then we'll bill against that at hourly rates. Or what I like to do, if possible, is contingency fees. So when we're representing a beneficiary, depending on the circumstances, we may be able to get paid a percentage of what we collect for them. So I enjoy those types of cases because it puts us right together with the beneficiaries. It aligns our purposes, and then we're searching for the best way to get results for them. So I've had a couple cases this week. That's why we're talking about this right now on the Friday webinar. And it's it's been fun. It's a lot of work, a lot of time, but I do find it enjoyable. So let's see here. Okay, so you ask, and then what do you do when they don't respond, or things aren't adding up? All right, so now let's get into the can you litigate nicely? I don't know. I mean, I can try, but I don't know. People don't always think I'm nice. So depending on, I try to be respectful, but it can be a challenge when you have opposing views to still keep the peace, so to speak. But when you're at odds, trying to achieve different results. The first thing I want to talk about is how do you approach a family member? So with estate planning, a lot of times we're talking about a trust. This is, the parents that manage it, maybe mom and dad are the trustee of it. That was a situation yesterday or earlier this week. I had some clients, we're doing an estate plan for them. They're setting up their own trust and digital asset trust, protecting their family. And as part of the process, we have the clients prepare an inventory of assets so that we can advise them on how everything should be set up, so it avoids probate and works together with their trust. So in this situation, they identified that he had an interest in an irrevocable trust, but they didn't know much about it. And his mom was a trustee. So, I let them know that we represent beneficiaries, but I realize it's a challenge. If you have a good relationship with your parents or whoever the trustee is, you don't want to damage that relationship. So how should you approach that? So what I recommend is just be open and honest with. A lot of times it comes up as estate planning when I'm helping someone develop their own plan. They realize that they're a beneficiary of another trust. So what I recommend, or one option I say, is that they can they can say, as part of their estate plan, the attorney identified, that there may be options for their interest in the trust that protects their family. So use that as a way to bring it up, to see if you can get a copy of the trust and get more information about it. The other thing I'll say is, weigh the desired outcome. What are you hoping to achieve with this? So you may be a beneficiary of a trust, and maybe on paper it says it's supposed to distribute to you, but for whatever reasons, the person's not following that. But there could be an even bigger trust as well. So that's what I mean by weigh the desired outcome. Meaning, if you are pushing it and say, "Hey, I want to see what my rights are under this trust." I see this a lot when their grandparents create a trust for the grandchild, where they might have a certain interest, and your attorneys and financial advisors out there may be familiar with ILITs, Irrevocable Life Insurance Trust, and crummy notices. But without getting too far into the weeds, there's some estate planning strategies where it allows a person to remove assets from their estate by making gifts on behalf of several beneficiaries. So to do this, you have to give notice. So when these gifts are made into a trust, in order to qualify for annual exclusion, so you don't have to file a gift tax return, the beneficiaries of the trust have to be given a right to withdraw, which is called a crummy notice. Crummy was the name of the case name. I always thought it was just a crummy job. No one liked doing those notices. It was one of my first jobs I got as a legal clerk. But no, it's a case name. So I see this a lot. So a grandchild may get notice saying, "Hey, you're entitled, a gift was made on your behalf to this trust. If you would like to withdraw, up to $15,000, you can do so by the next 30 days or whatever it is." So even though they had the right to withdraw, the strategy and big picture plan may be that grandpa is trying to download assets to give you even more later once he passes away. So if you take the immediate distribution, you could be giving up something later. So that's what I mean by weigh the desired outcome. Okay, so you've weighed the outcome. They haven't responded. You decided you still want to pursue this. So what should you do next? So the next step, I recommend hire legal counsel. This is a situation where you need legal counsel. I've told you, how to write your own will, other things, a lot that you can do without an attorney. But at this point, it's time to lawyer up. And then, as legal counsel, you want to make sure you hire good legal counsel. But what does that mean? What is good legal counsel going to do? Make sure you set deadlines and plan for what happens after each deadline. So part of this topic, can you litigate nicely? A lot of times what people do is that they're very nice when they're taking an adverse position, and they just try to get you to not worry about it or not look further into the details, and they try to brush you off very nicely. So that's what I mean by set deadlines and plan for what happens after each deadline. So here's some more tips. I should have done them as the animations, but I was just preparing this right before, as always. But anyways, can you litigate nicely? This is kind of almost rhetorical for myself as well. And so the tips, number one, refrain from, don't yell and curse. That seems obvious. Things can get emotional sometimes, and people can let themselves go to those emotions. That usually doesn't help the situation and can make it worse. So that's why going back to the set deadlines, plan for what happens after the deadlines, try to be methodical. At least that's my approach. So number two, have outlines for questions. So the other day I had a conversation with an attorney. So I'm representing the beneficiary, and I was speaking to the attorney who represents the trustee. Respectful law firm, respectful attorneys, someone that I admire in the business, but however, my position is adverse to them. So what I like to do is make sure that I plan out my agenda for the call, if it's a call, and have clearly the questions that I want to ask and get an answer to. And if and by do not get sidetracked, is focus on each one of those questions. So again, as people try to be nice as a way to brush things off. So sometimes it's a challenge in getting your point across, asking everything you need to, getting the information, but still doing it in a respectful way. So do not get sidetracked. What I mean by that is, so remember your outline for the conversation, and don't let people get stick to the outline. Don't take excuses or other stories. You want to get all the facts, but make sure you're being methodical and focused on the outline. So those are my tips for litigating nicely. I think it's possible, although it's still it's like it's a fuck you. It's hard to do it nicely. It still can hurt, even though it's nice. It can be a challenge. It is possible, but yeah, it's not easy. So, all right. So let's pull that out. So that's it for today's stream. Hope you guys enjoyed. I'd love to hear comments and feedback from other attorneys and litigators to how they practice nicely. Is it possible to be nice? Now, I talk a lot about what I call the old school attorneys, the old school approach, and I think kind of the old school approach thought being an attorney was an excuse to be a jerk, on behalf of their clients. But that's not the way of the future. I think that society changes, people demand more, people are demanding more service, and so the way that shows in their attorneys is resolving problems in a respectful way, and not making it uglier or more emotional than it needs to be. So thanks everyone for tuning in. Let's see, I'll pop up some of our banners on here. So if you want to schedule a meeting to review your situation, we can help you create your own estate plan. If you need a probate or trust administration, we can help with that as well. If you're a beneficiary or you think you might be a beneficiary and you want to know what your rights are, we can help you with that as well. Thanks for tuning in, everyone. I'll see you next week.